we're going to really focus on a huge issue in the documentary field, fair use, which is at a kind of real pivotal moment given the recent Supreme Court Warhol decision. And we have three of the leading experts in fair use with us today, which is great.
First of all, I want to say that all three of us are very, very grateful to DWORD and the entire DWORD community, but especially the leaders of DWORD who have created this community event. DWORD is a really crucial community for documentary filmmakers who are often put in this position of being really isolated from each other. And you've filled a real gap in the field. So we're very grateful to be here. Second, I wanted to turn to the people who have appeared, all 169 of you. And I wanted to say, it's really heartening to know that 169 people woke up this morning and said, I actually really need to know about the current status of fair use. Because you know what that says to us? It says that you're not in this position that you were when we showed up, Peter, Yassi, and me. Yassi, by the way, Yassi.
Sorry, Peter.
When Peter, Yassi, and I showed up with a big question for filmmakers in 2004, which was, do you have any problems with copyright when you do your work? And, you know, a whole lot of people told us, oh, no, we don't. We don't have any problems with copyright. We're like, really? Because like you use lots of material, copyrighted material. And people were like, you know, professionals, we don't have problems with copyright because we don't undertake any projects that would have problems with copyright. And we were like, oh, good, tell us more. Tell us about the projects you don't do because they would involve too many problems with copyright. And of course, that list just kept growing. And then when we said to you, you know, that the law is there for you to use so that it is actually possible for you to make your important films that comment on the culture that you live in, all of which is copyrighted. You were like, really? Well, tell us more. And the result of that was a code of best practices, which I'm going to post right here, which your associations created with our facilitation, that helped you understand what fair use is. And what's really exciting about this is that 20 years later, I run into these young filmmakers and I'm like, you know, that whole sequence in your movie, did you license any of that? And people are like, no, you know, I fair used it. Why wouldn't I? And I'm like, tell me more. So that's the sea change in the field. And it's not just the filmmakers. It's also the distributors, it's the insurers, and it's the broadcasters. All of these organizations, which have, you know, within the media companies themselves, there's a very firm understanding of what fair use is. They've just not often shared the fact that it's so widely used with the wider field. And to Doug's point, for those of you who are coming in, not having been part of that sea change of education, first of all, I want to turn you over to the Documentary Filmmakers Statement of Best Practices in Fair Use, which I just provided you a link to. Because first of all, I'm not a lawyer. Second, my two lawyer friends who are here at this event, Peter and Brandon, they cannot offer you individual advice because you're not their client. So all of us are here to tell you generally what the state of fair use is after the Supreme Court ruled on a very controversial case called Warhol. But that code of best practices, called the Documentary Filmmakers Statement of Best Practices in Fair Use, is a really simple, clear, layman's language version of what you need to know to do your work in fair use. And there's wrinkles way beyond that if you want to get complicated and you want to be weird and you want to live on the edge and be dangerous and strange, fine. There's a lot of, there's a lot more fair use out there for you to explore. But if what you want to do is do the kind of thing that filmmakers do every day, all the time, in employing exceptions to copyright that let you use copyrighted material without permission or payment because you've done so in a way that accords with the law, that's what you want to turn to. And of course, once you need your lawyer's letter, then you turn to my buddies, Brandon and Peter, who helpfully formed this little law firm to help you craft that letter that says to insurers, yes, a lawyer actually looked at this filmmaker's process and they employed fair use. And if you want to really lower your clearance costs even more, then when you deal with your lawyer, and Brandon and Peter are two of the most fabulous, because they're my friends. Also, they're really good. But there are others. Okay, wherever lawyer you go to, give them your copyright Bible, your list of what you cleared and what you didn't clear and why you did it, and write that Bible according to the documentary filmmaker's statement of best practices and fair use. That's going to do all the work that otherwise they would have to do for you and charge you for. Okay. So that's my non-lawyer's pitch. Now, let me tell you what's going to happen today. Brandon and Peter, the real lawyers among us, my PhD is in history, and I work in a communications program. But I have been adopted into the Washington College of Law's program on information justice and intellectual property for about 20 years. So I'm going to claim at least the knowledge of knowing the best. Today's what we're going to do is we're going to give you an idea of what happened in that lawsuit and how it affects your ability to employ fair use. And let me just cut the suspense here for a minute. Basically, the news is pretty good. Okay. And then after around 20 minutes or so, we're going to turn it over to you. And I can see that people have lots of questions already. So we can't wait to hear from you, and keep asking those questions in the chat, because I'm in charge of making sure that these gentlemen are going to answer for you. I believe that Brandon is going to start with his PowerPoint.
All right. You should be looking at our friends, Prince and Prince. As quoted, without payment or permission in the decision of the Supreme Court in Warhol v. Goldsmith. So I'm going to keep this canned portion of the presentation as minimal and streamlined as possible. And first, I want to echo Pat in thanking D-Word and the D-Word community for welcoming us in to speak to you. This is such an important group and such an important topic for this group to be aware of. So, the reason that Peter and I and Pat have been doing the work that we've been doing has always been to empower filmmakers and to give you tools that will help you make the great art that you make, right? And so the thing that terrified us about this opinion was that it would scare you, right? And make you worried that there are things that you were doing before that you can't do now, that somehow, there were movies that you wanted to make and now you can't make them, and so on. And so we were desperate, literally, emailing everybody we could think of within minutes of this decision coming out. Pat and I happened to be sitting next to each other at a conference at the law school that Peter has taught at for so long. And we were just taking turns reaching out to everybody we could think of to say, how can we tell people that this case is not a big deal, right? And so that's my message to you today. And we are thrilled, as I say, to have this platform to reassure you. So let me tell you what we're going to talk about. First, of course, I will cut to the chase and give you the too long didn't read version. so that if anybody needs to jump off, they'll have a sense of what's happened. But then I'm going to back up a little bit and talk about the state of fair use before this case. What was the status quo before this case was decided? Then we'll talk about the story of this case, because the story is both fun and interesting and extremely weird. And understanding how strange this case is will also, I think, help you understand its limited potential impact on what you would like to do. And so then finally, we'll end with a little bit of, so now what, right? What is fair use now? So first, the TLDR version, 3 things you need to know. The first thing is fair use has been a powerful and coherent user's right, at least since 1994, when the Supreme Court made a landmark opinion in the case Campbell v. Acuff-Rose that really set courts free to do what they needed to do to apply fair use in a way that was predictable and empowering. Okay. Second thing you need to know, Warhol v. Goldsmith is a narrow opinion focused on really strange facts relative to your community, certainly. And the opinion reaffirms repeatedly the core fair use principles that have operated since 1994. Most importantly, the case reaffirms the central role of transformative purpose, which has been at the heart of fair use for these last several decades and has been at the heart of the best practices in fair use for filmmaking and the way that I'm sure most of you have been doing your work. And if you've got a good lawyer, the way your good lawyer has been telling you, you can do your work. All of that was affirmed in Warhol. So the upshot, third point, documentary filmmakers can and should continue to rely on fair use when you incorporate third-party materials into your work for a new transformative purpose. And that includes the kinds of purposes described in the best practices, the things that you do all the time. Those things remain safe and reasonable. Okay, so let's get into it. Fair use before Warhol. The most important thing about fair use before Warhol is what happened in 1994. It is this case, Campbell v. Acuff-Rose, and I've grabbed that little cartoon from an openly licensed, amazing little comic book that was created by Harvard, the Harvard Library, to illustrate the story of Campbell v. Acuff-Rose. I'll make sure the link to that is in the slides when they go out to you guys after the presentation, but it's a lovely little comic book. But the story of fair use before Warhol is in many ways the story of Campbell v. Acuff-Rose and how it helped change the world. So Luke Skywalker in particular, that's what Luther Campbell used to call himself. Luke Skywalker and Justice Souter came to the rescue. So starting at the beginning, right? What is fair use? Well, fair use is this flexible, open-ended, a lawyer would say equitable, meaning it involves balancing different values. Common law, meaning it was made up by judges, not written down by legislators. And it evolved over time. It's context sensitive, so you have to apply it case by case, and it's got these 4 factors that you can find if you go read the Copyright Act. And it's all very kind of like, it sounds very important, and it is, and it has been for a long time, but it also sounds kind of confusing and unmanageable. It's something about unfair substitution and competition. That's what fair use has always kind of been. So if you go back, like the first fair use case in the United States, the big one that everybody reads in law school is called Folsom against Marsh. And that was a case in the 1800s about competing biographies of George Washington, right? And ultimately what the court talks about when it tries to figure out is the second biography, which borrowed some important material from the first one, is the second one a fair use? The court says, well, was it a substitute for the first one? Are people in the store going to pick up those two and say, well, this one's cheaper, I'll take this one? Or did it really add something new, right? And so this goes all the way back to 1840, but there's all these factors, there's all this stuff. It got very confusing, and it got especially confused in the 1980s after the fair use doctrine was first written into the law in the late 1970s as the big reform, the rewrite of the Copyright Act in the late 1970s. Courts really struggled in the 1980s with how to apply the factors to, especially commercial uses where there's money involved. And so there's a lot of confusion. If the user is making money, should they always, just because they're making money, have to throw a little money back to the copyright holder or ask their permission? And things got pretty incoherent for a while there. One of the judges who was repeatedly overturned and really frustrated about it was a guy named Judge Pierre Laval, who now sits on the appeals court in the Second Circuit in New York. And Pierre Laval finally, in a fit of frustration, tired of getting reversed and never understanding what, how his opinions were going to be treated by other courts, and feeling like fair use was kind of a mess, he wrote this really influential article about fair use. And that article was really influential because in 1994, when that Campbell v. Acuff Rose case came to the Supreme Court, Justice Souter incorporated Judge Laval's article into the Supreme Court opinion. And what was in Judge Laval's article was this really powerful idea: transformative use. So Judge Laval said, look, what matters in thinking about fair use is whether the fair user, or the so-called fair user, the person who's asking to be seen as a fair user, is doing something new and different, is contributing to the culture, and going all the way back to the 1840s, the Folsom against Marsh case, not merely creating a substitute for the thing that they borrowed, right? Not competing unfairly. So this is sort of our buddy Luke Skywalker bringing balance to the Force, right? A transformative use is a use for a new purpose and not a substitute for the work used, right? A transformative use adds new culture to the world. It creates something new that serves a new purpose. And that's what copyright is really about. And so that's part of why copyright has a fair use doctrine. Copyright is meant to encourage the creation of new culture. And when someone is engaged in a fair use, the copyright law says you shouldn't have to ask permission or pay when you do that. We want you to just create, right, without being fettered by the limitations that copyright might otherwise place on you. And once this transformative approach, this question, this notion that you should ask first, am I doing something new? Am I creating something new that is not competing unfairly with the thing I'm using? Once that approach is codified in that Campbell case, the lower courts slowly but surely begin to pick it up and use it. And then scholars started to study what the courts were doing, and what they saw was that if your use was transformative, you won. That became a real deciding factor, with the only other factor being whether the amount you chose to use for that purpose was also appropriate to that new purpose, right? And so the court would say, look, you say you're critiquing this piece, but did you take an amount that is appropriate for the purpose of critique? Or are you really trying to catch a free ride by taking the whole thing, or taking way too much relative to that critique purpose? And what was also important about that sort of amount relative to purpose thing is that when new technologies came along, and when you had also uses that involve things like images, where it's sort of awkward to try to use less than the whole image, right? If you're critiquing something like an artwork or a poster, you might need to reproduce it in its entirety in order to do the critique. There had been one of these sort of myths that was around about fair use before Campbell and transformative use took over, was that fair use is really about small uses. Fair use is about something that's sort of insignificant and not really noticeable, and the less the better, right? And fair use is a kind of uses that nobody really cares about because they're so tiny. And that's not the case. That's not really the way the doctrine works. Again, it's about a use that is for a new purpose. And sometimes the new purpose requires the entire work. And so we get cases like Bill Graham Archives v. Dorling Kindersley, which is about a coffee table book about the Grateful Dead, right? Which I rediscovered the Grateful Dead lately, by the way. I'm becoming a deadhead to my wife's great consternation. The Dead and Steely Dan, I might end my marriage, but that's why I have to be down here in the basement with my records. So anyway, great coffee table book about the Grateful Dead. And part of what that book has in it is a timeline of the history of the Dead, and it's an illustrated timeline. In fact, the book is called An Illustrated Trip. And on that timeline are little reproductions of concert posters, among other things. And of course, you couldn't sort of cut it in half, right? Like a concert poster, like the bottom half of the poster wouldn't work, nor the top half. You need the whole poster to represent the poster. But also, the book is not competing with the posters, right? No one is going to buy this book and cut out the posters and put this little thing on their wall to decorate the dorm room, right? And of course, the concerts are over. So the real original purpose of advertising these concerts and getting people to go is long gone. And so again, the court in that case said, well, you took the whole work, but you were illustrating a timeline and helping people to get a feel for the aesthetic look and sort of who were they playing with and where that time of year and so on. And all of that is new and all of that is transformative and legitimate. And so using the whole work is fine in that context. So new purpose, appropriate amount. And then the last important insight that we've had is that scholars have shown that courts care what people do in their actual practice, right? So courts care about the norms in a field. And so this is the insight, along with the other two, when you put them all together, that's what powers this best practices movement that Peter and Pat have started with the filmmaker community as the first, but certainly not the only. So there have been several other communities that have developed these best practices codes. And the reason they do it and the reason it works is because you can understand transformative use and apply it to your circumstances. You can rely on it because you know that courts love it. And when your use is transformative and the amount is appropriate, you will win. And you know that courts care how you in your community think of what's normal as a practice in your community. So when you have a kind of organized conversation and you develop a consensus about what is good and normal, and that norm takes hold, you can do things like get insurance, right? Based on the fact that you're doing work that is normal within the bounds of what documentarians do and how you rely on fair use. Okay, that's a lot of background, but as you'll see, it's important because all of that is still basically the law. But let's take the detour into Warhol, the Warhol v. Goldsmith story. So it all starts with Lynn Goldsmith. Lynn Goldsmith is a rock and roll photographer. She takes these photographs she's published in Rolling Stone, she's published in big magazines, and she's a major kind of path breaker as a female photographer in this realm, right? And so she's a significant persona in her own right. And early in the 1980s, when the artist, then known as Prince, later known as a few other things, and then finally known as Prince again, Prince was just breaking out, and Lynn Goldsmith took this portrait of him kind of in a hotel room in Minneapolis between tours, right? And she only got him for a few minutes. She took a few awkward photos. She tried to sell them to Newsweek. They didn't buy it. She kind of held on to them. So the story begins, right? So Goldsmith now has this collection of portraits of Prince. A few years later, so that's like sort of 1981-ish, if I remember correctly. And then sort of in 1984, Purple Rain breaks out. Prince is like becoming a mega superstar. And Vanity Fair wants to run a big spread about Prince. focusing in particular on his sexual, his kind of dirtiness, right? And so they have this purple fame theme. Prince is this rock star who's come to fame in part by being sexy. And Vanity Fair wants to hire Andy Warhol, who's then a hireable gun, right? He will do illustrations for you in a commercial way for the right price. And so Vanity Fair pays Andy Warhol to create an illustration for this Prince article in 1984. And then Vanity Fair also pays Lynn Goldsmith a license fee, $400, so that they can give her photograph to Andy Warhol to use to make his sort of screen, to do his thing, right? Which is to turn a photograph into a screen print, et cetera, right? It's a well-known method. So in 1984, Warhol relies on this licensed photograph and creates an illustration for Vanity Fair. And part of his process is he makes a lot of these things. So he ended up making like 12 or 13 prints, right? Prints of Prince. And, he figures out which one he likes best. He shows it to Vanity Fair. They like it too. It's in the magazine. The credit next to the photograph in the magazine is to both Warhol and Goldsmith, right? So it's illustration by Andy Warhol based on a photograph by Lynn Goldsmith. Okay, cut to 2016, right? We all remember it was a sad, sad day, right? Prince dies like suddenly, unexpectedly, and is found dead in Paisley Park. And there is an outpouring, as there should be, of like reckoning with his career and celebrating him and writing about him and thinking about him. And Condé Nast, the publishers of Vanity Fair, created a kind of special commemorative magazine just about Prince and his life. And they went back to the Warhol Foundation, right? Now Warhol is dead, it's 2016. But his foundation is managing the estate and managing the art and licensing it. And they say, hey, Andy always made a lot of those prints, right? So you got any more prints for us? And the foundation dug out like 14 and said, yeah, which one would you like? And so Condé Nast put this orange Prince on the cover of the 2016 magazine, but they did not this time ask Lynn Goldsmith's permission or give her credit or give her any money. Now, Goldsmith was in the business of licensing these images to be on the cover of magazines all the time, right? So here's an issue of Musician magazine from back in the 80s, and she licensed one of her Prince photographs from that same portrait session to be on the cover of that magazine. And in 2016, when Prince passed away, there were lots of magazines about Prince, lots of commemorative issues and celebratory magazines, and lots of people were putting images of Prince on the cover of the magazine to convince people that this is the magazine you want if you want to learn about Prince and celebrate him. So there's an active market for Prince images on the cover of a magazine. Well, that was the problem. So when we get to the Supreme Court, Lynn Goldsmith sees, let's back up. Lynn Goldsmith sees this thing on the magazine stands and says, wait a minute, that's my Prince. Last time they did this, I got $400 and my name was next to the photograph. I haven't heard anything about it. What's going on? She reaches out to Condé Nast and Warhol and says, what gives? And then the Warhol Foundation sues Goldsmith. Warhol Foundation sued Goldsmith and said, we're going to sue you before you sue us. This is a fair use, go take a hike. So the case winds its way through the courts. And by the time it gets to the Supreme Court, there's really, the issues have been sharpened substantially. And the only question for the Supreme Court was about the first fair use factor, which is where the courts consider the purpose and character of the use. And that's where courts consider transformative use. And so it's really important. It's a really important factor. And the Warhol Foundation said, this is transformative because it has a different meaning, right? Andy Warhol's version of the Prince print, it has a different vibe. It conveys a different sense of Prince. And that should be enough. The district court agreed and said, yeah, it's a Warhol, just look at it. It's definitely a new work. But the appellate court disagreed, and the appellate court said, fundamentally, these two images are serving the same purpose, right? They are illustrations, images of Prince. They're being sold to magazines to be on the cover of the magazine, to attract buyers to purchase the magazine about Prince, right? They're in the same market. Somebody, unlike, for example, someone who would say, be in the market for a Grateful Dead poster, they would not be satisfied with the Grateful Dead timeline book, right? They're not going to go buy that book and then cut out the little, 2x2 poster and put it on the wall. Or the Luther Campbell, right? Campbell v. Acuff Rose was a case about the rap "Oh Pretty Woman," the rap version, which was a parody that was about a big hairy woman, right? Nobody's going to go to the record store and say, well, I came here looking for Roy Orbison's Pretty Woman, but this one's cheaper, so I'll take that one, right? But it turns out lots of people were looking for illustrations of Prince to put on the cover of magazines about Prince. And Goldsmith and Warhol were in the same market, trying to get a piece of the action, selling their illustrations of Prince. And so the Supreme Court, in deciding this case, found in favor of Warhol. And the reason they did is because the two works were fundamentally, in this use case, focused on the same market. They were attempting to exploit the same group of consumers with the same media, right? And so the decision focused on that purpose and the purpose of this particular use. Now, let's talk a little bit about fair use now, post-Warhol. Purpose is the key. That's what we learned from Warhol. It was because the two illustrations were being sold in this context to the same market, to fundamentally do the same thing, to illustrate magazines about Prince, right? In particular, to be on the cover of magazines, to attract people to buy those magazines. Use is also key. This is a little bit of an innovation in the Warhol opinion. I don't think it matters that much to you all because for reasons we can talk about. But the court here says, and this is often lost in the conversations about this case, the court says the use is what we're evaluating, and the use is licensing to a magazine to put it on the cover, right? And for some of my other clients in the library world, this was really a huge relief because the court said, if Warhol wanted to sell these prints to a museum to hang on a wall, that's a different use, right? That's not competing with Lynn Goldsmith's magazine licensing business, right?
Sorry, Brandon, if I can just jump in for 1 second. I think you mentioned that Warhol won the case. Didn't you mean Goldsmith won the
I'm sorry, yes, Warhol lost the case. Goldsmith won the case. So Warhol lost, and I'm so sorry, yeah, very important distinction. So Warhol lost. And the reason Warhol lost was because the Warhol Foundation was licensing into that same market that Goldsmith was. But again, Warhol could win a future case if the use at issue was, for example, selling to a museum or displaying or creating the print in the first place, right? So the court doesn't say it was unfair to make art. The court says it was unfair to license the art in competition with Goldsmith in the very same market where she is. So the upshot is, right, purpose is still the key.
Brandon, I'm just going to pile on here. it's not your opinion or our opinion that it could still be art, right? Like the decision itself goes way out of its way to say, look, there's lots of other ways that Warhol doing this very thing could be fair use.
That's exactly right. Like, yeah, this is not me hypothesizing or guessing or sharing my personal views. Like the court says explicitly in the opinion, if Warhol were to sell this image into a different market or, use it in a different way, all of this that we're talking about in terms of the magazine cover would not apply in the same way, right? And so the court says that very clearly. And so they're focused on this particular use, the licensing use into that market. And so the last thing that I think is interesting in the case and that's important is new meaning and critical message are still extremely important, right? So it's not the case that, criticism doesn't matter or making new meaning doesn't matter. It's not the case at all. New meaning and criticism are very important because what they tell you is when you are using something for a new purpose. So when you see new meaning and new message and you see criticism, that can be really important evidence that you're using something for a transformative purpose. And again, transformative purpose is the North Star, as it has always been. So what does that mean for doc film uses? Well, the core doc film uses that we see every day when we're doing this work and that y'all engage in persist, right? Those uses continue to be fair and reliable, right? So subjecting media to critique, right? Talking about culture, right? Bringing culture into your film and addressing it. Using media as evidence in your argument, right? Incidentally captured media that is part of the reality in your film, and bringing in media from radically different contexts and incorporating them in a new context in your film for a new purpose. All of that stuff is as powerful and important and legitimate as it ever was. And so, the upshot of the Warhol case really is it was a fascinating and strange case that, gave the court an opportunity to sharpen a couple of things around the edges of the doctrine, but it did not change the core meaning of fair use, and especially not in contexts like the ones that y'all are in every day. So now, and that was longer than I meant it to be, but this is, we'd love to have Q&A with y'all and talk and see if we can answer questions you have.
So there are a bunch of questions, and it's my job to kind of find some threads through. Oh yeah, they want me to turn on my camera. There we go. So one thing that people are asking different kinds of questions about is when should you ask permission? And so these range from, well, my subject is dead. Who do I ask permission from? And is it better always to ask permission? And then if they say no, you can say, well, then I have to fair use it. So could you just speak to this very elementary thing about how does a fair use actually work? Does it start with asking people permission and then they say no? And if you can't find that person, then what happens? Just really basic.
It's a great question. It's important, like foundational. The first thing you should know about fair use is that it is not an excuse. It's not a fallback position. It's not a second best option. Fair use is your right. And it says that in the law, the right of fair use. You can look it up. And so you can absolutely rely on fair use without asking. And in fact, in many cases, from a pragmatic point of view, it's better not to have that conversation because the person, obviously, who you might ask would love to have your money, right? And so if they're not entitled to it, starting that conversation could be really awkward if it turns out you decide to rely on fair use. And so generally, as a pragmatic thing, it's nice to understand fair use and to know before you talk to someone whether you're going to rely on it, and perhaps to choose not to have that conversation, because you don't have to have that conversation if your use is fair. There's nothing to gain from that conversation if your use is fair, unless there's special circumstances, right? And there are sometimes those special circumstances. And here, Peter, you're on mute.
Let me jump in there, because sometimes there are special circumstances. Sometimes the license holder may have better materials than you're able to find on the internet, and you may hope for higher resolution materials, or perhaps you feel ethically constrained and would like to be able to make a deal with this originating copyright owner, even though it's your right, literally, not to do so. The other important thing to know, therefore, is that you don't lose any fair use points, so to speak, by asking permission and then failing to get it. There is no, sometimes, I don't know if they still do it, but sometimes I used to run into lawyers who would say, oh, you never want to ask, because if you ask, you're conceding that the copyright owner has rights that you will otherwise have to respect. And that, of course, reflects or reflected of a fundamental understanding of what Brandon has just described. That is the nature of fair use as a right. But if you have a good reason to want to engage in an attempt to secure permission, you're free to do so. And if at the end of the day you're unsuccessful, your fair use rights will be no less, maybe even under some circumstances, because you endeavored to do the right thing. By your ethical lights, your fair use rights may even be a little better if you engage in that exploratory conversation. There's one other thing which you've all encountered, and that is sometimes you make an effort to license material and the effort falls flat. You can't find the rights holder, or you can't find a rights holder who's interested in bargaining with you. Well, that is also potentially important fair use information. If in fact it turns out that a piece of material, an image, a piece of footage, a text, whatever it may be, is difficult or even impossible to license, that fact is likely to contribute to and bolster the fair use arguments that the filmmaker user has, rather than in any way to diminish them.
So I just want to
Pat, I'm sorry. Let me jump in for 1 second to clarify something. Sorry for the confusion, folks. For some reason on our Zoom, Julie, our program manager, her chat notes appear coming from me, and it actually is easier if we use the raised hand function, and Pat can call on people who have the raised hand rather than asking the questions in the chat. Maybe that's better for commentary. But if you obviously
let me just try to deal with a couple of points of confusion before we turn to people. And Doug, you're in charge of telling me which in this forest of yellow hands.
do it in the order that you see it on your screen. Fine. I guess.
Good, but there are some. There's first of all, let me remind people that these wonderful gentlemen who are just full of knowledge cannot use that knowledge to address an individual question about your situation. For your own situation, you need to go to a lawyer, for instance, them, and have contract with them to deal with your problem. However, there are some general questions that keep coming up that let me just, in case this will apply to any of the hand raisers. First of all, people are like, well, would this be fair use? Would that be fair use? And so if you guys could speak to this question of like, fair use is contextual, and then the way in which the contexts are often very similar too. So it's not just this gray area where like you never know. And then the other question is international. Like, how does this? Great, this is okay in the U.S., but I'm actually doing co-pros and I distribute my film internationally. Then what?
Let me say something. Well, yeah, let me say something about this question of context. It is very important to understand that fair use is context sensitive, absolutely, and that's good, right? Because if it were, sort of written in the law exactly when it applies, the legislators would get it wrong, right? They would fail to anticipate something important. And so instead we have something that's more flexible. The kind of flexibility, though, that we have is not the same as unpredictability. So often you hear sort of like fair use is, it's case by case. And people say that in a tone that suggests that it's a coin flip. It's you never know what it's going to be. You got to, every time you do something, you just take your chances. And that's definitely not the case. Fair use is context sensitive in the sense that it depends on the thing that you want to do, whether what you want to do fits into this broad transformative purpose category, right? And so when people try to generalize about fair use and you hear these kind of rules of thumb, the problem with rules of thumb is not that they're too general, it's usually just that they're bad rules, right? And so people will say something like, well, if it's less than 30 seconds, it's always okay. Or, as long as you're taking content from something that was on YouTube, it's okay, or whatever, right? And often in particular, you hear rules of thumb that are about only amount with nothing about purpose, right? Or rules of thumb that are about only source with nothing about what you're doing with that source. And so people will say, well, if it's a local news, it's always fair. If it's this, it's always fair. And I see lots of questions in the chat that are a little bit like that. Like, can I just always use this kind of stuff? Is that always fair? And it's hard to give a categorical rule about kinds of stuff, because again, what matters is what are you doing? And so that's why the best practices work so well, because they're not really about kinds of stuff. They're about what are you doing? Why are you using the stuff? What is your purpose? And so it's much easier to say, kind of as a general matter, bringing in third-party material because you're criticizing it is generally going to be fair, right? It'll be case by case. You want to look at, how much do you need for that critique in that way? But generally it's going to be fair. So those are the kinds of generalizations that are possible. And yet, even though you can generalize, of course, each case has to be sort of looked at to see, is the amount appropriate and so on. So that's the give and take of the context.
So Brandon, Peter,
let me just add a word, if I may, which is that another way of putting that is that although fair use is always contextual, it's also highly patterned. And the patterned character of fair use means that it is also highly predictable. And you may need a lawyer to help you get started on the project of making the best possible use of your fair use rights, but you shouldn't need continual hand-holding thereafter throughout your filmmaking career. Our clients get remarkably independent very fast, even to the extent that they didn't come into their work with us feeling confident about their fair use judgments. So someone may say, well, fair use is uncertain. And that, of course, in the literal sense is true, because all legal doctrines are uncertain. It's uncertain what constitutes negligence in an auto accident. But it is also highly patterned and therefore highly predictable. And that, I think, is the most important reason, perhaps of all, to have confidence in the doctrine and its application.
Brandon, Peter, we have like a ton of people with raised hands. So I do want to get before we ask, and one I just ask that we give as succinct, questions and answers, because we only have a half hour left. But can we, I don't want to forget touching on the international question about fair use.
Let me try to be succinct. The most succinct thing to say about fair use internationally is that although fair use by that name in essentially the identical form to the one that exists in this country probably exists in only 8 or 10 places around the world by estimate, every copyright jurisdiction has major exceptions written into its laws for the creative reuse of old material without permission or payment. And one often sees those referred to under the broad heading of quotation rights. And it is therefore the case that, generally speaking, if you have a strong fair use argument to be able to do something in the US, you will also have a very strong argument under the laws of most other significant film market jurisdictions, if not all, to do the same thing. The other thing that's important to know is that these days in general, errors and omissions insurance policies that are written by US underwriters based on an analysis of US law provide worldwide coverage.
Great. Thank you.
So what I would like to do is to ask the people who have their hands up, I'm going to ask people 3 at a time to ask their questions so that we can get a sense of what the questions are out there. Starting with Lizzie McGlynn. Unmute, please.
Hi. So my question was, generally speaking, about if you feel somehow threatened by somebody that may be a rights holder, if that would bolster your argument at all for fair use, that if somebody was, if you felt like it could put yourself in physical or even worse legal types of danger, that's a little ambiguous. Let's just go with physical danger, if that would bolster a fair use argument. That's it.
Thank you. And Mabel Valdivieso.
Yes, hi. My question is, many filmmakers, I think, are facing this, meaning like there are fair clips from news sources that we want to use, and even there are archival footage, considered archival footage, but now some of them, or many of them, have put those clips over the years, and now I see them very frequently in big platforms selling for a lot of money. So if the filmmaker uses this, then is that, considering that you, the filmmaker, are using all the fair use principles, how is that situation where the big companies now representing this news still or not applying to potential fair use or not?
Thank you very much, Mabel. And also that's a more general question as well about stock footage. Judith Ailey.
Yeah, my question is, I'm recently seeing in license agreements, and probably other people can second this, language where they're actually asking you to sign away your right to make fair use of any copyrighted material, anything copyrighted to them or to collections that they represent. And my question is, can you sign away your right to, First Amendment speech protection?
Great. Okay, so I'm going to let these gentlemen provide some answers to that. And my apologies in advance to people I'm calling on. I can only see what's on my screen. I don't know who started, who was here first. So my apologies to everybody. Okay, Brandon and Peter.
You want to start?
Sure. So I'll start, and I'll, again, mindful of all these hands. I'll be shockingly, I'll be as brief as I can without being irresponsible. The threat question is totally fascinating. It's novel to me.
Yeah.
The thing I would say is go back to that question of purpose. Why is someone threatening you in connection with this footage? And if the reason you feel, if the reason the rights holder is so hostile is because you're doing something with the footage that they deeply oppose, I wouldn't be surprised if what you want to do is for a different purpose than whatever they were doing with it in the first place, if that makes sense. And it might also be critical. It's something that they're not going to like, which is similar to parody. That big Campbell v. Acuff-Rose case was a parody case, and the court said, situations where you want to use work to criticize the rights holder, and the rights holder wants to use their copyright not to make money, but to censor you, right? That's fair use will not tolerate censorship. So when you, as the copyright holder, are taking a censor approach, I think that's going to strengthen the fair use argument, all else being equal. News clips, two answers to that. When someone puts something into a platform like Getty, for example, or a big licensing house platform, that has two impacts on you. One is if you get it from that platform, odds are pretty good you've entangled yourself in a license or an agreement by implication or explicitly that if you use the footage that you got from them, you'll pay. So when you get footage from a source, you're obligated typically to deal with that source. You can't walk away and then say, haha, I'll fair use it. There's probably exceptions to that, but that's a good thing to have in your mind. But the other thing to know is if you don't get it from that source, right? So the news producer has put all its stuff in Getty, but you've got a copy that you found at Vanderbilt or UCLA, right? In the news archives there, in the clear. Well, then the fact that they're asking for money over here doesn't have any impact on your fair use if what you're doing is for a new purpose, right? And that's an important thing to know about the Warhol case. I think there's been a misunderstanding that Warhol means, you can't do something commercial or you can't do something when someone else is engaged in commerce. That is not what the case means. You can absolutely rely on fair use even when you're doing something commercial, even when they want your money, when what you're doing is for a different purpose. Last question, can a license take away fair use? That's a really cutting edge legal question. That is, I think it's open. The conservative, like, if you're being careful kind of answer would be if you sign something that says you won't do something, including making fair use, there could be a contract claim that would say you breached your promise, right? You said you wouldn't do this and then you did it anyway. And so even if copyright says it's okay to do fair use, you promised you wouldn't do fair use, right? So it's sort of similar to, the law says I'm free to do whatever I want with my time, except I've promised my bosses that I'll go to work from 9 to 5. Well, they can sue me if I don't go to work from 9 to 5, because I promised I would, right? So same issue there. If you promise that you won't do fair use and then you do it, you could potentially be in danger for breaking that promise.
So I'm going to Joe O, Hannah Shepard, Kevin Massman.
Wait, Pat, let's go back to doing one question at a time, please, because it's very hard to keep track of the questions when three are thrown out at once.
Okay, great. John?
Hi, my question has to do with news material, so TV broadcasts and like morning talk show kind of things. I have subjects in my film if I want to use brief clips of that just to demonstrate them as being experts in their field. Is that permissible?
So, right.
Well,
So I'm going to take a shot at it. And keeping in mind, again, like we can't give you legal advice for your specific scenario, but the question to ask should be getting clearer now, right? The question is, why are you using these morning show clips? What are you doing with them? And how does that compare to why they were made in the first place? So I would probably be pretty optimistic in general about taking little clips from an existing show in order to prove something, right, about a completely different subject, right? So those shows, the point of that show was not to establish that your person is an expert, I assume, right? They were on there to talk about a particular topic. So now you've taken that and put it into a different context. That sounds pretty new purposey to me, right? You'd have to show somebody that footage and talk through the details, but new purpose is key, and I'm hearing new purpose.
Okay, next.
Yeah, I'll take over for calling on people since I'm able to call on them in the order that they raise their hands. So Kevin, you've been up for a long time. You next.
Hi, thank you. I'm wondering if fair use applies to the use of locations, or is that a completely different thing?
So fair use applies to the use of copyright protected material, right? And so then the question, in fact, a lot of times when Peter and I are working with folks, questions sort of evaporate at the very first stage, which is there a right? Is there a right that you have to be worried about? And so in terms of a location, you'd have to ask, well, like what right are you worried about violating or needing to clear? And so that would be the first question. Is there, for example, did you film on location and incidentally capture some images that were on the wall, right? Posters or something like that? Or did you incidentally hear music that was playing over a jukebox? That's copyright protected material, but then we could talk about fair use there.
Okay, Francelle, you're up next, then Don, then Elle.
Hi, thanks. I'm curious if you're expecting your release to start out outside the US. Do you recommend people just go directly to an attorney in that country? And do you ever see people make one cut for an international release for certain regions and then just cut out things in America if America's more conservative about that? I know people can sometimes get around this by using a different IP address, but most people still, I think, don't know how to do that. So yeah, questions like that, just how closely do you work with attorneys in other places?
Yeah, so the basic legal answer there is that the law of copyright is territorial, right? Sort of it matters where you are. And so if your film is literally going to release primarily somewhere else, then the law in that place is going to be primarily the law you have to worry about. So I wouldn't go releasing films first in a non-US jurisdiction without talking to a local lawyer there. But we've worked very closely with lawyers in other jurisdictions. We've got a production right now, and we've got a UK lawyer talking about fair dealing, and we're talking about fair use, and it's very doable.
Great, thank you. Don?
Yeah, so my question is, what can a filmmaker do to save money on getting the clearance letter? Is there information I can provide to an entertainment attorney who's doing this?
Yes, absolutely. The best thing that you can possibly do to sort of save everybody time and shorten your billable hours with an attorney who's doing fair use review is to keep good track of what you're putting into your film, where you got it, where did you literally get it? What is the source? But also then who do you think owns it? What was it originally published for, in what context? Like, what is this thing? So a good description of the material. And then just like a really nice time sheet, cue sheet that tells me exactly where this clip is, what is it, where did it come from, who do you think owns it, where did you think it was originally published. What's really lovely is a little screenshot. That's kind of above and beyond perhaps, but it makes it so much faster for us to review something as the fair use attorney. The other thing that might be helpful, honestly, is to talk to, believe it or not, and this may sound counterintuitive, talk to someone early. Talk to an attorney early in your process, so that you can get a sense from them of what is going to be on the right side of the line in their opinion, and then you'll be able to make choices that are more easy for the attorney to say yes, 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 right? Because you will have a sense of what they are willing to, support. So talking to someone early, believe it or not, is good. That upfront investment will pay off in the end.
Brandon, why not send you or the entertainment lawyer the clip itself, or even if it's in the scene already cut, so that you can see the context for it being used?
Sure. So two things on that. One is if you have a link to the original, right? If you got something, if your source is online, so that we can see what was this clip in its original context. Because again, the key is the difference, right? So helping us know as much as we can about the original context is good. And yeah, if you're in the middle of production and there's an important decision you need to make, right? Does this clip stay or does it go? But you don't have a full cut yet, right? You don't have a rough cut or a fine cut, but you need a call on that bit. Absolutely. We've had people send us a clip in context and say, what do you think about this as a fair use? And we do need the context. We need the in and out. We need to know why you're using this piece, because that's the key.
Great. Thank you. Elle, you're next.
Hi, thank you. Hi. So my question is, if one records secretly in American courts, which is illegal officially, can one include those secret illegal recordings? I know it's an absurd question in a way, but to my mind, we're exposing corruption and sort of the inner workings, and one could argue that it's the public's right to know. And so I'm just wondering, want to see where that lands.
I'm going to dodge that one for a couple of reasons. It's very specific. It sounds like you need some specific advice on it. And also, it's not really a copyright question, right? It's really a question about whether you violated some other laws in the context of getting this footage. So you're getting a little beyond our core expertise here, and something we probably can't get into right now.
Peter, you're up next. And you're muted, yeah.
Yeah, no, I see that. Jono asked a particular question about talk show clips. I think many of us are using news footage, broadcast news. My question is, then when we use it for a documentary film, is that considered a different market? Is it not a different market if it's streaming? The new purpose, the new culture, I think most of us can handle that. It's the market question, I think, that I'm worried about. Thanks.
Absolutely. It's a great question. Generally speaking, I think you've got, you're gonna, again, as I mentioned, it's hard to say, this is a category of fair use based on something other than purpose, because purpose is really the core. So it's hard to say, well, news is just always fair, or local news is always fair, or chat shows is, there are uses of those materials that might not be fair. But when you're bringing those materials into a documentary film, I've seen lots of fair use contexts for those materials. Like they're what Peter and I have a term we use called fair use eligible, right? That's the kind of category, that's the kind of use we would need to watch particular clips to help you, make decisions. But you're in the ballpark, right? It's a fair use eligible category. And the market in that context, I think you could argue, depending again on exactly what you're doing, is different, right? That is, the market for a talk show is people in the morning who want to have coffee and watch a light chat. And if the reason you're bringing material from a talk show into your film is weightier and orthogonal to that, well, then it sounds like you've got the beginning of a nice story about a new purpose. And that's where fair use lives.
Great. Hannah, you're up.
Friendly face. Hi, Hannah.
Hi, everyone. Yeah, I had a question about the Goldsmith-Warhol case specifically, because one thing in reading about it I didn't see anywhere was whether Goldsmith was aware that when she licensed the photo to Vanity Fair that it was going to Warhol, which seems like a really crucial, important detail. And I was wondering if this case is actually like more an issue of like poorly written contracts than it is fair use. So I was curious about that.
I think that's extremely perceptive, Hannah. I think it is in many ways a case about a bad contract. If anyone involved in that first agreement had a little bit more foresight, we would never have gotten here. But I'm pretty sure, based on the opinion, I've read all of the opinions in the case, all the different, there are 3 now judicial opinions. I haven't read everything. My understanding is Goldsmith did know that she was licensing the portrait as a reference photograph to be used by Warhol. I don't know. I suppose she could have known it was just going to be used by somebody, but she did know it was going to be a reference photograph, one-time use only. And that's why she was sort of shocked and confused when she saw it again in 2016.
Well, Brandon, I'm trying to still wrap my mind around why Warhol, what grounds the Warhol Foundation had to sue her. Could it have been because of the initial contract somehow, or?
It's because they felt threatened. So
well, yeah, but I mean, what did they state the reason for suing her was?
Because they expected her to sue them any moment now, and they needed to clear the title. Like, if you have a reasonable expectation that somebody is gonna, pose a legal threat to you and disrupt your business, you can sort of go and try to get a declaratory judgment and say, look, I want the courts to tell me that what I'm doing is okay. And I see the comment in the chat. It's a bullying tactic, and it's kind of ambiguous, right? Who's bullying who? Sometimes these declaratory judgments are a good way to stop bullies, because somebody will send you a nasty letter, and it's very easy to send a nasty letter. I've done it myself. It didn't take a minute. And you don't have to prove anything to any kind of an expert to send a nasty letter. You can send a nasty letter that's kind of frivolous. And so it can be useful when you get one of those letters, if you've got time and money, to just go to court and say, prove it, right? You sent me a nasty letter. You say I'm violating the law, prove it. And so it can be a way to push back against bullies. Here, maybe the Warhols were being the bullies. It's less clear.
I also think that it's possible that and I have no special insight to this effect, but I think it's possible that in devising this litigation strategy, the Warhol Foundation lost sight of a fundamental proposition about fair use, which we've been discussing for the last 90 minutes almost, and that is that context matters a lot. I think they may have believed, and certainly the district court, the first court that heard the case, seemed to agree with them, that there was something so particular, so special about the Warhol treatment, that once an image had undergone that treatment, it was somehow, I don't know, it was sort of lifted up permanently into fair use heaven. And really, if there is a cautionary reminder for all of us, lawyers and filmmakers alike, in the Warhol decision, it is that context matters. Yes, fair use is predictable. Yes, fair use is highly patterned. Yes, we can learn how to do fair use well and to depend on fair use as a right, but we should never imagine that there is any special privileged category of creative activity that is always going to be a fair use, regardless of the context in which it is made. And that may have been the thought error, if there was one, in the approach that the Warhol Foundation took to the case.
Great. Thanks for clarifying. Hi, Malkia. You're up.
Hi. So this is a question about helping the field establish norms. I've never thought about like what my role is as not just an independent producer who uses archival, but I'm often the archival producer who's preparing the fair use logs. And, you know, I don't write opinion letters, and I always say I'm not a lawyer, but I am helping advise clients, like, you're not gonna get away with that, but you could do this. Like, how can we be bringing in the best practices in a way to help advancing that as a norm? I've never thought about how we could be doing that.
Wonderful. Yes. I mean, you're the front line, like that, a smart, mission-driven archival producer is just priceless. And someone asked earlier, what can I do to lower my legal bills? And it's like, have an archival producer that understands fair use, because they will help you make those choices, and you'll have a film that comes to a legal team that's easy to approve. So yeah, it is important, and you all have an important role to play in making these choices, in line with the best practices.
And to that, I'd only add that, and I mean, it's already been specified and stipulated that we're not the only lawyers who do this. There are lots of lawyers who do this. There are lots of lawyers who do this very well. But I do think that it's been our experience over years that, at least on some projects, it's good to have a legal advice function lined up earlier rather than later. That lawyers who watch or have the ability to watch early cuts and answer questions about them may be in a much better position to collaborate effectively on behalf of the filmmaker with the frontline staff, including archival producers, than would be lawyers who are asked only at the very end of the day, we've done all this, we've finished. Can you write an opinion letter now that says it's okay? And all things equal, one hopes we can. But if you are able to involve your lawyer in a somewhat more kind of collaborative way over the course of post-production, or even in some cases production itself, you may get a greater benefit from that advice.
Hillary Pierce, good to see you put a shameless plug in the chat that you do archival producing. We strongly encourage shameless plugs. So anybody else who does that or wants to put a shameless plug in the chat, please go right ahead. David Spodek, we go back an awful long way. Good to see you. Hello. You're muted.
Hello, Doug and everyone. Thank you for, I wasn't sure you'd take me. Yes, Doug and I are old friends. This is my first visit to any chat or Zoom for your wonderful organization. Very quickly, I may have, what if you make a film that is about the subject, that the subject is the complete copyrighted entity? In other words, you make a film, in this case, about a film, and the entire film, right, a copyrighted, produced film owned by somebody else, is embedded in your film along with complete deconstruction, analyzing it from a educational point of view. So it's no longer the film it was, even though the entire film is embedded, chopped up, along with original footage and narration that has nothing to do with the film. How does that fall into this fair use thing? Where the subject is, you know, you're not using a clip, you're using the entire thing. And that's the subject.
Well, Brandon spoke before about how important a consideration the amount of material that copyrighted material that is used can be in making a fair use judgment. And he also said something else very important, and that is that sometimes the appropriate amount of material is the work in its entirety. That depends on what you're doing and what the nature of the project is. But there's absolutely no bar or barrier that would prevent you from, no sort of categorical exclusion that would prevent you from investigating fair use along the principles that we've been describing for a project that involves incorporating a whole text or a whole still image or a whole audiovisual work as the object of discussion and commentary. Obviously, this is it's a liminal question. It's not the kind of question that comes up daily in fair use analysis, but it is a question to which that analysis is entirely appropriate, and depending on circumstances, to which the answer might be yes. Going back to something that I'd said before about working with lawyers and working effectively with lawyers, this seems to me to be an unusual enough case, if I understand your example, so that it might represent a very good instance of a situation in which it would be good to talk to a lawyer sooner rather than later about what you actually have in mind, about the specific nature of the use, about the relationship of the added material to the incorporated material. But it is a potentially eligible case depending on those circumstances.
Brandon and Peter, you are being very generous today, not giving us billable hours, but I do want to respect your being lawyers, the fact that we're at the 90-minute mark. We have a few more questions. Are you okay about spending a few more minutes, or should we call it a day here?
I can linger for a while.
As can I.
Okay. I see 5 more questions, and I'm going to cut it off there. No more raised hands. Kenji, Ruben, Thomas, Benjamin, Edward. Go ahead, Kenji.
Thank you very much. Quick question. I copied online an actual event, Steve Jobs announcing a product, which is now embedded in an animation of a character witnessing this event. Is that relieve it in some way from being a copyrighted material? By the way, these events that Steve Jobs does are public events. They are photographed by Apple, and the copy is some crummy copy that I found online. And does that relieve me of copyright issues?
No, it does not, but it does make you eligible for thinking about the possibility that your use may be a fair one. In other words, what you've done doesn't affect Apple's copyright in any way. Apple's copyright remains, and there may be a variety of situations and circumstances in the world against which Apple could enforce that copyright should it choose to do so. Your use may not be one of them. And that depends on whether your use qualifies as fair under the criteria that we've been discussing today, which involve, as you remember, repurposing, the use of appropriate amounts of material that is appropriate to your new purpose, and some consideration of whether what you're doing puts you into direct head-to-head commercial competition with the rights holder of the material in question.
I just also want to encourage you to go back to the documentary filmmaker statement of best practices and fair use. You would be amazed at how many times your question is answered by that document.
Pat, could you put a link to it once again in the chat? I know you've done it.
I just did.
Okay, very good. Oh, there it is. Amazing. Ruben.
Hi, thank you for your time and your expertise. So my question is almost philosophical. It's not. So a song is not made for being seen, is to be listened to, right? And when we filmmakers use a song in our movies, many times we transform it. We shorten it, we do some basic editing, there might be some audio over it and stuff like that. So the question is, why are we paying for music?
It's a great question. And it goes to a couple of important kind of big, it's, as a recovering philosopher, like all good philosophy, it goes to important big questions that will be helpful. So one of them is transforming is really not about changing. It's not literal transformation. So the fact that you like cut it down or move it around or, that's not really what the transformative thing is about. Again, it's really about transforming the music from music into something, right? Some other purpose than music. And the reason you're paying for music when you're using it as just like soundtrack, right? Like just, hey, I want my audience to feel good, so I'm going to find a feel-good song and put it here. That's what music does. Like, that's not a new, innovative, repurposing of music. That's the thing that music is in some sense always doing, and it's what it's for. And kind of more cynically and legalistically, it's a market that music producers expect to exploit. Like when I write a song, which I sometimes do, but they're never any good, right? But if I were ever to write a good one of the things I would hope would be people will put my song on their soundtracks, and that's one way I'll pay my bills, right? Like it's a normal market. It goes back to that question of like, what's normal? What do people normally do? So yeah, now, if your documentary, to the question that was asked a moment ago, is about music, right? And so you have to hear the song to understand the point that's being made, right? Nothing was ever the same after, the Kinks first used distortion or whatever, right? Like and you got to hear it, right? That's evidence in your argument. And it comes one way, I think of it sort of metaphorically, it comes out of the soundtrack and into the film, right? And becomes subject of your story. But when it stays in the soundtrack, that's the normal market. That's not transformative, unfortunately.
Thomas.
Yes, thanks, Doug, and thanks, Peter and Brandon and Pat, for your time. Making a historical documentary, a documentary about an event that happened that has been largely overlooked. Instead of just having all talking heads, you have photographs and you have news clips from that era. The question is, use of newsreel clips about this event in this film about this event, is that transformative at all or not?
And here I think that probably the most helpful, and I don't mean to be evasive, but the most helpful thing we can say is that what you're describing is part of a category of uses that are fair use eligible. In other words, uses that are worth talking through and thinking about in order to discover whether the patterning of those uses in your film overall and in particular instances fits the criteria that we've just described. And you can obviously do quite a lot of that for yourself using the materials that are available, including the documentary filmmaker statement of best practices. But again, on a project the success or failure of which will depend on your ability to incorporate this kind of material on a non-licensed basis. It may also, again, be the kind of issue about which it would be worth talking sooner rather than later to a lawyer about what in particular you have in mind. But yes, those are all fair use eligible uses, which is a different thing from saying that they are all necessarily fair uses, a conclusion which would necessarily depend on more information and more analysis.
Quick interjection before we get to the last two questions. If you need to leave and want to save the chat, which I highly recommend, lots of good links and information in there. Just go to the bottom of the chat box where you see where you type your message in. You'll see 3 dots and just click on those and you'll see the save chat button icon. Also, a reminder that we will have this up on a recording of this up on our D-Word YouTube channel within the week, I would think. Many thanks to Philip Shane, who has been doing our guest editor while Michael appoints away. So thank you, Philip. Okay, Benjamin and then Edward, and then we wrap up. You're muted, Ben. You're muted, Benj.
Hi, sorry about that. This is my first discussion. So glad somebody told me about the D-Word. Thank you guys for your time. I had a simple question. If you're using material you believe is like 100% fair use, or as you say, fair use eligible, would it be wise to back that up with just a couple sentences on file if somebody were to somewhere down the line, no matter when film's finished, say, hey, I don't like this? Is it wise to like write that down and say photo file XY whatever had to be used to demonstrate or show purpose for this, just to back yourself up? That's what I was wondering. Thank you.
It's an interesting point. So the quick answer is the best way to protect yourself that we know of when you're engaging in fair use, but people, especially people who make money by licensing things, don't always appreciate fair use. The best way that we know of to protect yourself is to get a good errors and omissions insurance policy that covers fair use. And a standard E&O policy doesn't necessarily do that. The way that the insurers have developed to accommodate fair use, which is huge, which has been hugely revolutionary in the industry, is that they will insure fair uses, but they want to see a log that represents the fair uses in your film. So that's where it makes sense to make a note, right? Keep track. The things that you're not licensing, they want to know what are those things. And then they want an opinion letter from a lawyer that says, I watched this film, I have this log, everything listed that's not licensed, I agree is fair use. So that's the ultimate, kind of approach that we're aware of for protecting yourself against possible threats in the future.
Great. Thank you, Brandon. And final person for questions, Edward, bring us home.
Hello. Kind of a follow-up maybe to that, but I was just wondering, I just finished a very archival heavy film and had an attorney on retainer to watch it and give their thumbs up, and then to be on retainer to any challenges. But I wondered, like, what should I be asking when hiring an attorney in terms of how far they would pursue challenges, and like, what does an initial challenge look like? Is it usually like a cease and desist letter? Like, how do you typically see bumps in the road happen?
We can say a few things, and Peter can jump in and add. Right. So one thing, and I promise I'm not trying to brag, we've never seen a bump in the road with a project we've worked on. That is, they're not dragons everywhere waiting to pounce on you if you do the right thing. We've not had anybody we've written a letter for who've ended up having to defend what they've done in court. So, if you do the right thing and you get good advice, this is not a dangerous place to be. But that said, right, what does do the right thing look like? Well, it goes back to that insurance thing I was describing a minute ago. And this is another, I promise I'm not, this is a little bit self-centered, but I want to tell you something really important. Peter and I don't litigate, right? We're not, if somebody sues any of our clients, they do not want us to be the ones defending them. Not because we don't know how to make a fair use argument. Obviously, that's what we do all day. But there's a lot to litigation that's not about the substance of the law. So you would need an expert in defending you in court. It's a different lawyer, different kind of lawyer. Some people, could do it all, but we definitely do not. And the way that this works generally is that when you get insured, the insurer is going to choose the lawyer because they're paying. So now they may give you a menu, and I think some insurers have sort of like 20 law firms that they approve of, and you can say, well, I want this one. I'm not sure. We're not insurers, but the insurer is going to pay the fee. They're going to defend you. They're going to be the ones kind of in charge of the lawyering that happens on the back end. So, suffice to say that the person who advises you and gets you insured is definitely not necessarily the person who's going to be there when something happens. But again, if you get good advice and you have a good insurance policy, nothing's going to happen. Almost
to
certainly.
that, I would just add that the one thing you don't want to do and as Brandon has already pointed out, it is indeed an unlikely event, so far at least in our practice, an event that's never occurred. But in the event that you were to get a cease and desist letter about a film that has been insured, the one thing you don't want to do is to enter into or have the lawyer you've retained or your brother-in-law or anyone else enter into correspondence with the sender of that cease and desist letter, because the terms of your insurance policy say that the first thing you have to do is to report the claim to them. And then subsequent decisions about how the claim is going to be handled will be made in consultation. But if you say, well, I'm going to try to resolve this without reporting it to my insurance, you run a significant risk of invalidating that insurance policy.
Brandon, Peter, and Pat, much gratitude is being expressed for you in the chat. Before we head out, are there any final thoughts you want to leave us with about anything?
I want to say that people like Therese and David and so many other people who've been chiming in on the chat are super important, because every day new people are joining the field of documentary film. They didn't hear of fair use. Nobody told them there was a documentary filmmaker statement of best practices. They might have heard all kinds of outdated and fantasy advice from PAs or really anybody. So being able to continue this work to let filmmakers know what the law encourages them to do, because they're doing valuable work creating new culture. That's really God's work, people. And it can't be up to Brandon and Peter and me to do it. Because this is not a lawyer's right. This is a creator's right. And so if you don't tell people, if you don't tell your interns, if you don't do intern training on how to employ fair use, if you don't make them read the documentary filmmaker statement of best practices, the next generation doesn't know. So I would just want to thank everybody who's like, I love that Therese calls herself a fair use nerd. Thank you. But this is your work to do, is to make sure that that knowledge is passed on to the next generations.
And one way that we do that, on the D word itself, we have a legal topic, and fair use is discussed an awful lot there. And we have a search function, so you can search within the topic for specific terms. So that's one way to keep it alive. But on everybody's behalf, Brandon, Peter, Pat, thank you so much for your time and expertise. This was truly invaluable, and so appreciate you taking the time.